Courts determine questions of facts and questions of law. And if you are in the middle of a lawsuit or you're about to enter into the court process, it's important that you know the difference, because there's going to be numerous hearings, and some hearings will be on matters of fact and most will be on matters of law. So a matter of law, a question of law, is always directed to the judge, and you're asking the judge to essentially interpret and apply the law. And usually this is a procedural question. So for instance, maybe the claim is an old claim that the plaintiff is making, and the defendant is arguing that the claim should be barred due to the statute of limitations, and that would be a question of the law. What does the law say? And does it apply favorably to the defendant? So there'll be a motion filed, there will be a hearing set up, and the parties will go to the hearing based on that motion. And it will be a question of law. A question of fact is typically decided by a jury, and this is ultimately the decision of a trial. All right, if it's criminal, it'll be guilty or not guilty, and if it's a civil case, one side will be liable or it will not be liable. All right, and those are most often questions of fact, directed towards the jury, unless the jury is waived and you have a bench trial, and in that case the judge will answer both questions of law and questions of fact. All right, so it seems like a technical thing, but it's not. And if you're in the middle of litigation, you're going to have to go to multiple hearings, and it's important that you understand the difference, because sometimes I'll see people go to hearings and it'll be a procedural hearing over a question of law, and only the lawyers are able to speak, and they'll typically only talk about this law and cases that affect the law, and the client doesn't know what's going on. The client's getting upset and they want to go up to the podium or the mic and just start ranting about all the facts and all the history behind the case and this and that. And it's unfortunate, right? That client doesn't know that hearing is not the time or place for those sorts of arguments. All right, so just be aware there's two types of questions: questions of fact, which is typically directed towards the jury, and it's usually the ultimate conclusion of the case: guilty, not guilty, liable, not liable. And questions of law, which are usually procedural questions, and they are always directed to the judge.